Is Nathalie de Rosiers, and I'm the General Counsel for the Canadian Civil Liberties Association, and I'm also a law professor at the University of Ottawa. Ça me fait plaisir évidemment de vous accueillir ici pour cette session sur le 30e anniversaire de la Charte. We're here to have a session and a debate on the Charter at 30. First of all, I want to say this is a session that is part of the Equity and Diversity portfolio, and I want to thank Melinda Smith, who was the outgoing Vice President for Equity and Diversity, who was the one that invited us, the CCLA, to join the Federation to organize this panel. So I'm delighted that we have this great panel here to discuss the issues of the Charter Act 30. But I would start simply by a couple of remarks about why the Canadian Civil Liberties Association would be interested in doing a panel at the Federation on the Charter at 30. The Canadian Civil Liberties Association exists since 1964, so it existed before the Charter. It was an NGO before the Charter. And it did cases, constitutional cases, and tried to protect civil liberties before the Charter. And it was quite present in the debate surrounding the adoption of the Charter. Since then, I think we have seen, and we continue to be, I think when you are in the work that we do, at this special place between the aspiration of the Charter and the reality of what goes on on the ground. And this special place, I think, allows us to probably continue to think that it's not only lawyers, and it's, I think the entire academic community must continue to reflect on what was the role of the Charter, what is this gap between what it says and what indeed is going on on the ground and through the decision-making process. So today I arrived last night back from Zambia, and you could be interested to know that Zambia is doing now a constitutional reform, and they have now the idea of including socioeconomic rights. And it was interesting to be there for several days and sense the excitement, the exhilaration about putting words to democratic aspirations. And in a way, I think I was reflecting on the flight back how we were here going to look a little bit more carefully at what does it mean 30 years later. Jean-Pierre Ferland is a Quebec songwriter that says women it's at 30 that women are beautiful. Before they're pretty, after ça dépend d'elles, it depends on them. And one of my questions was whether the Charter Act 30 was beautiful, whether indeed in its youth it had this exuberant position where many of the early cases seem to indicate some strong positions and some almost strong positions were taken by the court. We saw, I think, I would say, at the 10 or 15-year anniversary, kind of a rebellion where there was some contradiction, as though it was becoming a teenager, and there was some internal contradictions that were becoming more obvious that I think young adulthood from the 20 to 30 have not completely resolved, and that's part of what our authors are going to be talking today. So sans plus tarder, I'm going to introduce our panel, and we'll start with Carissima Mathen, who is an associate professor of law at the University of Ottawa, and she teaches constitutional law, criminal law, and comparative civil liberties. She has degrees from McGill, Osgood Hall Law School, and Columbia University. She was the director of litigation for LEAF, and she also was a professor at the University of New Brunswick, she certainly has written widely and is often a commentator in the Globe and Mail on constitutional issues. So her current scholarship focuses on arbitrariness in criminal law and the referent function of the Canadian courts. She is the co-author of Women, Law and Equality, a discussion guide published by Irwin in 2010, and she has 15 minutes.
Well, thank you very much. It's really a pleasure to be here. It's always a pleasure to have an invite from Nathalie, who's a good friend and colleague at U of O, and I really appreciate being asked to participate. Although I must admit that when I was first advised of the topic, I was seized with some dread, because it really seems to be very unwieldy, almost ungovernable, if you might say. And so what I propose to do is I'm just going to make some comments that came to my mind when I was thinking about this topic, equality, dignity, freedom, and then bring it back to a case, which I think can sometimes be helpful in terms of making some points, and it's certainly a case that has exercised me much of late. So equality, dignity, and freedom are really, I would say, the essential values that undergird the Charter itself, and accepting for a moment that they actually correspond to distinct strands of, assuming for a moment that they actually correspond to distinct strands of social and political value, we can see them reflected, I think, in different places in the Charter. So obviously equality we can see reflected in sections 15, section 28, I would argue as well, in the mobility, democratic, and language rights. Liberty is, of course, the core unifying principle of the fundamental freedoms. It also is extremely critical to the specific legal rights, section 7 through 14, which obtain in the criminal or quasi-criminal setting. Dignity is more amorphous. Interestingly, in recent equality jurisprudence, the Supreme Court of Canada has somewhat minimized the importance of dignity to equality in terms of section 15, but it is clearly an essential underpinning. I would argue, too, that dignity can be seen as a product of constitutional structure. So the means by which people have access to argue cases in court, the expectation that governments will offer some justification for rights violations, and the duty on courts to award appropriate remedies. My own history with the Charter began as a first-year law student in the year that the seminal case of Andrews was released. So, for those of you who don't know, that's 1989. And there, the Supreme Court really cast off some of the shackles of our past. They articulated an understanding of equality as focused particularly on whether a law has the effect of imposing burdens or withholding privileges from persons who could be identified by certain group characteristics. And this particular perspective, which is sometimes called substantive equality, ushered in a greatly expanded period of judicial review of legislation that on occasion has resulted in quite bold decisions, including in the areas of LGBT and disability rights. There were as well discrete and important victories with respect to women. The court, for example, rejected precedent under the Canadian Bill of Rights that treating someone differently because they were pregnant had nothing to do with their being a woman, because not all women are pregnant, and anyway it's a condition that you choose voluntarily. And that actually, with some modifications, is still the approach of the US Supreme Court, for example. The Supreme Court in a case called Brooks, under the late and very influential Chief Justice Brian Dixon, rejected that principle, as they did in a number of other areas as well. But what is interesting about these victories with respect to women, which is going to be my focus here, is that they tended to occur outside the specific constitutional context. So they didn't occur in specific charter cases. They occurred in non-constitutional cases where the court engaged in a process that we call incorporating so-called charter values, which it did in the areas of human rights or family law. In fact, in terms of initiating a sex-based equality claim, women have yet to enjoy a charter victory at the Supreme Court of Canada. They've won cases where equality claims have been launched against them or against their interests. So they've won claims where they have been on the responding side, but they have never actually won as initiators of a Section 15 equality-based claim. And there are numerous reasons for this. For one thing, happily, we have rid ourselves of the most blatantly sex-discriminatory practices. But this leaves an entire range of laws and policies which continue to produce sex-based disadvantage, but are very challenging to demonstrate and are much more threatening for the courts to enter into. One area that has been a perennial challenge is criminal law. So criminal law engages all three of the values that we're talking about today, but obviously it is naturally most preoccupied with an individual's right to actual physical liberty, and understandably so. This concern has shaped much of the Charter's jurisprudence or case law on legal rights, but it's a focus that runs the risk of being ahistorical. So for example, and myopic as well. So a pure focus on the threat to liberty that arises in a criminal case can rationalize grossly discriminatory rules, for example, in the area of sexual assault. And a great deal of my time at LEAF was spent litigating cases where the equality rights of complainants came into apparent conflict with the rights of the accused to a fair trial. And through great effort and over time, and it's been a bit of a pendulum, LEAF, together with other groups, was able to persuade the Supreme Court, and equally importantly, Parliament, that sexual assault inescapably implicates our commitment to equality. The feminist position in these cases often ran contrary to those of, say, the Civil Liberties Association, and frankly, it was a battle that I always found very invigorating. It's interesting, though, when the feminist and libertarian position can actually coincide, as I have found increasingly to be the case in some recent controversies. And in my view, when this happens, I think we should be put on notice that we are faced with a true moment of choice with respect to a threat, potentially, to equality, dignity, and freedom. And the example that I want to turn to, where I think a feminist and a libertarian perspective does coincide, is the issue of polygamy. So just to ensure that we're all on the same page, Section 293 of the Criminal Code makes it an offense to be party to or to assist in the solemnization of a polygamous marriage or a quote-unquote conjugal union involving more than two persons. It has been an offense since 1892, which is the date of our first criminal code. There are only 2 recorded convictions, and they have happened, each of them, over 60 years ago. But for over 10 years, the British Columbia Attorney General has been trying to bring charges under Section 293 against some of the male leaders in the community of Bountiful, which practices a form of Mormon polygamy. So polygamy is a very highly fraught issue. In its most common form, it's associated with a type of familial arrangement that appears to be inherently unequal, and that is the practice of polygamy, where one man takes several wives. There is social science research suggesting a correlation between this kind of polygamy and various economic, physical, and emotional harm to women and to children. It can arise in a context of religious isolationism, even extremism, and that produces external skepticism about whether a true choice is actually being made by all the parties to the relationship. At the same time, many women in these relationships insist on their capacity to choose and demand society's respect, or at least freedom from punishment for that choice. So instead of a battle between the equality rights of one group and the liberty rights, say, of another, here we appear to be faced with a choice potentially between equality and liberty as they reside in the same subject, women, all the while struggling to determine which outcome is most consistent with dignity. In the interest of time, I'm not going to go over the procedural details of the polygamy case, but I can do so in questions. A reference was put to the British Columbia Supreme Court. A reference is a special proceeding where the court is essentially asked to provide its advice about a legal question. In this case, is Section 293 consistent with the Charter? And the British Columbia Supreme Court in November of 2011 found that indeed Section 293 is consistent with the Charter, save for one narrow issue it identified with respect to charging people who are minors, who are underage. So I just have a few comments I'd like to make that hopefully will tie back to the theme. And I should say that I have an article breaking down the decision much more completely that is forthcoming in the Supreme Court law review. So the most common argument in favor of criminalizing polygamy is that it is inherently harmful to at least some of the participants. There are two really big problems with this argument as it relates to Section 293. The first problem is Section 293 itself doesn't actually require proof of harm. So it risks convicting people in relationships that fall under its umbrella where there's no interpersonal actual harm present, or at least where the Crown is not proved as such. This is especially the case because while all of the social science evidence around harm relates to polygamy, which is the practice of one man taking many wives, the Code criminalizes polygamy, which is not gender specific with respect to the breakdown of the parties in the plural relationship. So the law in charter terms is grossly overbroad. It sweeps far larger than what could be its intended object. The second problem with this argument, the harm argument, is that Section 293 criminalizes everyone who is party to the polygamous marriage. So assuming that the law exists to protect women, it has a very odd way of doing that. It makes them liable to imprisonment. And this is, of course, a perverse outcome that can be attacked in legal terms as arbitrary. Now, a possible solution would be to tinker with Section 293 itself, and there's a long tradition in the criminal law of courts reading in certain elements into criminal provisions to correspond to other concerns, in this case, charter concerns. So a recent example of this technique in an unrelated case is the Ontario Court of Appeals decision recently in a case called Bedford, which was a challenge to several prostitution-related offenses in the criminal code. And with respect to one of those offenses, living on the avails of a prostitute, which was targeted at pimps, but was worded in a way that the Ontario Court of Appeal found to be overbroad, and to actually make the conditions under which sex workers engaged in that work unsafe, the Ontario Court of Appeal decided that that section of the criminal code should be interpreted to only permit a conviction where the Crown has proved exploitation. Right? So it reads in this element. Now, as an aside, I don't think that kind of technique actually works for Section 293, which is an argument that I'm happy to get into later, but at least it would be an understandable attempt to deal with the problems of overbreadth and arbitrariness. What is interesting in the reference is that the Chief Justice, Justice Bauman, didn't even try to address these problems because he had a very different take on polygamy itself. Rather than viewing polygamy in terms of interpersonal harm, he viewed it as an existential threat to our very society. Basically, he made the following argument, relying heavily on something called evolutionary psychology. The basic argument is that human nature actually favors polygamy, so people will actually naturally tend towards polygamous unions. And so early on, we developed a norm called socially imposed universal monogamy. It's been pointed out to me this is a terrible acronym, but it's sprinkled all over the 265-page decision, so this is what we get. And it first arose in ancient Greece and Rome, and according to Justice Bauman, accepting some expert evidence in the reference, it explains Western civilization. Okay? It is strongly associated with the development of republicanism, citizenship rights, high levels of collective action. It's even more speculatively associated with increased GDP. Okay? It is, monogamy has this miraculous power. It's very, very important. And decriminalizing it would lead to dire consequences. That's the quote on GDP. It's actually a very fun quote, but I won't read it. I should point out I am taking this, these are direct quotes from the decision. The chief danger of decriminalizing polygamy is that it would create a greater pool of unmarried men who would, quote, take substantial risks so that they can eventually participate in the mating and marriage market. And the court accepted that men unable to secure wives are more likely to engage in criminal behavior, including murder, robbery, and rape. In other words, decriminalizing polygamy would open the floodgates to a powerful male id that has just barely been subdued over the last 2,000 years and would quickly overwhelm society. So, après monogamy, la déluge. This is why the court ultimately concluded that Section 293 is constitutionally valid, even if it convicts people whose intimate relationships in and of themselves are not harmful. It doesn't matter, because that's not what the polygamy law is all about. And this is what I find so disturbing about the case, and I'm going to make a very provocative claim. I think the polygamy reference is the single worst decision, charter decision, of the last 30 years. I think it's the most dangerous, the most regressive, the most in need of review by a higher court, or to be relegated to the dustbins of jurisprudential history. At its core, it employs an aggressive legal moralism to justify a remarkably punitive law, and this is seen by the court's casual dismissal about the concern about criminalizing the women who are in these polygamous relationships. I question whether the capable consenting spouse is a victim. To the contrary, she can be seen to be facilitating an arrangement which Parliament views as harmful to society generally. More fundamentally, the reference incorporates biological essentialism as a justification for criminal law. The entire momentum of the criminal law, long before the Charter, since the Hart-Edlund debates in the 50s and 30s, has been away from this trend. The reference posits a bleak model of male personhood and a despairing picture of female victimization. And the reference's use of these biologically essentialist terms is dangerous because it legitimates punishment based on the crudest of group generalizations. Finally, the reference distorts history and social science evidence, completely whitewashing the reality of women's oppression within the reality of marriage that 98% of society experiences, right? Monogamous marriage. If we are truly concerned about equality, dignity, and freedom, particularly for women, we will not fall into the seductive trap of using criminal law to promote their equality. We will not permit dangerous stereotypes to inform our laws. We will do the hard work of approaching those who are different from a position of respect. We can't shirk from taking the necessary steps to protect the vulnerable. But let us at least be honest about where that vulnerability lies, about how far it extends. Because of one thing I am sure, to the extent that there is such vulnerability, it extends far beyond polygamy. Equality, dignity, and freedom, these values often seem to be commensurable, to use a word that the Chief Justice of Canada seems to like a lot. When they are perceived as incommensurable, it's my experience that women often lose out. The greater challenge is to recognize the degree to which they are interrelated and mutually reinforcing. The polygamy debate raises essential questions about the society that we wish to have. The response that will best serve the Charter's purpose and its continuing potential is one that recognizes that these values need not and must not cancel each other out. Thank you.
Thank you very much. So our next panelist is Ryder Gilliland, who's a litigation partner at Blake's, and he is the editor of the recently published The Charter at 30, which happens to just coincide with the theme of this conference. Ryder has been a great help to CCLA in particular. He has represented us many times, and he has been named a litigator to watch and to hear, I would say, in the Lexpert survey of Canadian cross-border litigators. Was recognized by Lexpert as one of Canada's leading lawyers under 40. He's appeared as counsel at all levels of court, and he speaks regularly at many conferences. And I have to say, he's someone that you can count on to respond to even helping people that need some help, particularly in defamation case and media law. He's been quite an expert on this, and I'm really thanking him for being here today.
Thank you very much, Nathalie, and thank you for having me. It's a pleasure to be here. I'm going to talk a little bit about freedom of expression, because as Nathalie alluded to, that's where much of my practice, certainly my charter-related practice, focuses. And there have been a lot of developments in the area of freedom of expression in the last 30 years. However, the theme of my talk today is that if you look at what's happened in the last 30 years with respect to various cases, which have actually received quite a bit of acclaim, they're not charter-driven changes. They are more so the charter accepting changes or the courts accepting changes through the charter they're already largely societal norms. And I think, having had the experience of editing this Charter 30 collection, that maybe the freedom of expression experience is not that different from many other charter rights, in the sense that we often see the courts really playing catch-up rather than being the engine of change. And I think for those of you thinking of law school or law as a sword and a radical tool, it can be a frustrating tool, and courts, I think, are inherently conservative, and so change is slow to come. Let me sort of put all that in context by stepping way back, talking about freedom of expression too. And I should add, before I get into it, I see freedom of expression in three branches, which I've categorized, but I think they're fair. One branch is what the law allows you to say, free speech, which is what we all, I think, traditionally think of in connection with freedom of expression. And the primary regulators there are the law of defamation and hate speech. Other aspects of freedom of expression are open court, which is the right to hear, in particular to hear what's going on in our court system. And the third branch is access to information, and in particular access to government information. And we just had a case, I think 2 years ago now, which recognized what they call a derivative right through Section 2B to access government information. So those are the three branches that I want to talk a little bit about, all sort of continuing with this theme that although there's been significant cases, there really hasn't been significant judge-driven change. So to put all that in context, we think about going back over a century ago, the early 1800s in England. If you said something about something defamatory, which would be interpreted very broadly, about people in power, you get a trial at the Star Chamber. Your trial would be held in secret, and you'd have no right of appeal. And invariably it would result in you going to prison in 1800s England. So you can imagine what that did to promote open discussion. Fast forward to the States in the 1960s, when obviously there had been a lot of societal change. People were no longer being thrown in jail necessarily for opposing those in power, but it was a time of great uproar. And the New York Times ran an advertisement in support of Martin Luther King in Alabama. It resulted in a lawsuit against the New York Times, which was brought by effectively the sheriff, the commissioner in Montgomery, Alabama, against the New York Times and several civil rights activists. Tried before a jury in Alabama. The jury awarded $500,000 US against the New York Times. These are early 1960s US dollars, so probably the largest award to this day ever, if you adjust it for inflation. That case resulted in the New York Times and Sullivan decision, which of course dramatically changed the law of defamation in particular in the United States, such that it's made it very, very hard for a plaintiff to succeed in action for defamation in the U.S. There's an actual malice standard. And as a result, the number of defamation claims against newspapers in the U.S. is down very dramatically. And of course, that decision was couched under the First Amendment, which had been around for a long time. But the court saw the light and invoked the First Amendment to protect that free speech at a time when there was, of course, radical change and a change. So the decision, in my view, reflected the change that was incoming. The jury in Alabama reflected the status that was rapidly changing, and so you see the court in that case following the lead of basically the people. And similarly, in England, of course, the S.C.R Chamber did not overturn itself. There was a social change that led to eventually the abolishment of the S.C.R Chamber and open courts and a more just judicial process. So all of that's, of course, way before the Canadian Charter. But if you fast forward and look at what's happened in the last while in the area of defamation, two decisions that have received a whole bunch of attention as being progressive decisions are one, a case out of BC, WIC Radio, and that case involved a broadcast on the CBC about an individual in BC who had been very active, very vocal against gay curriculums in schools. And Rafe Mayer on a CBC show equated the type of thinking behind this individual and her movement with Nazism in Nazi Germany. That ultimately, I can't go into the details of the technicalities of the case, but ultimately it was protected by the Supreme Court of Canada as fair comment, and in doing so, the court actually changed the law of fair comment in Canada to bring it in line with, they said, charter values. More recently, just a bit more recently, there was another decision, Toronto Star versus Grant. Grant was is a fellow in Northern Ontario who had made a lot of money through forestry, lived on a lake, and had a 3-hole golf course, but I wanted to expand it to, I think, a 9-hole golf course. And he'd had some connections with the Conservative government, and the story said that he was using those connections to try and help him with his permitting to expand his golf course, his private golf course. The Star quoted Cottager, most people on this lake were Cottagers, quoted Cottager saying it was a done deal because of his connections with government. That case was tried by a jury in Northern Ontario, resulted in a damage award of $1.4 million against the Toronto Star, which was outrageous when you think about what the story was actually about, and it went up to the Supreme Court of Canada. And similarly, you think of some parallels to the New York Times and Sullivan case, because it was a crazy jury decision, goes all the way up to the Supreme Court of Canada and makes new law, in this case, the defense of responsible communication. What's, I think, most important for purposes of my talk today, though, is that in both cases, the law of fair comment and this responsible communication law had already been established in England before the Supreme Court of Canada adopted them. So when these arguments were made before the Supreme Court of Canada, it was just a matter of saying, you should do what the courts in England have done. And to their credit, the Supreme Court did go along with that, but the point is, they weren't doing anything radical. They were adopting law that had been established already in other common law jurisdictions. And in fact, in the case of Grant, we're also basically undoing what I think most people looking at it objectively would have thought was quite an extraordinary decision by that jury. So again, that's along with the theme that these are great decisions and they're touted as victories for freedom of expression, but they're really not radical changes in their own right. I'll deal more quickly with the second and third branches. So the second branch is the open courts and access to justice. There's a 1996 decision called Dagenet, which is viewed as the sort of leading case on access to justice and open courts. And it remains a very, very important decision, and it's involved all the time in ensuring that we get information about what's going on in the courts. But as I alluded to at the outset, the concept of open courts was really starting to blossom about over 150 years ago when the S.C.R Chamber was abolished. And so it's hardly a novel concept. In the early, once Canada was formed, there's early Supreme Court of Canada decisions way before the Charter talking about the importance of openness and quoting the English House of Lords from much, much earlier. So again, important decisions, charter-driven decisions, but really only effectively giving support to what was already in existence. Finally, and much more recently, a couple of years ago, we were involved in a case called the Criminal Lawyers Association, which is a case about access to information. And in that case, the information in question was a police report, and I don't have time to go through the details of the case, but the case was factually a very good case to drive forward to get the Supreme Court of Canada to recognize an actual constitutional right to access information. And this, by the way, is recognized by the UN and all kinds of international organizations as a fundamental right, and has been recognized as such, I think, since as early as the UN Declaration, so as early as since 1948 at least. So again, not a new right by any view. And the Supreme Court of Canada, again to their credit, recognized a right, but they called it a derivative right, flowing from Section 2B, so not a freestanding right. And they qualified it, I think, in a significant way by saying that you have a right to access information, but only if it's to promote meaningful discussion. And of course, that raises the question: what's meaningful? Who gets to decide? And what is that right ultimately worth? And we got to get a taste of that last year when we did the Information Commissioner case, and I was fortunate to intervene on behalf of the CCLA in that case. And we were trying to get access to, believe it or not, just the agenda of the Prime Minister. This actually goes way back to Chrétien, so the wheels of justice going very, very slowly. So we're trying to get that information, and effectively the Supreme Court's ruling upheld the courts below in saying that, yes, there is a right to access to government information, but government doesn't include the Prime Minister's office or any of the cabinet offices. So, in other words, you can have access to information within the bureaucracy, but if you want to get information from where the decisions are made, the Charter is not going to help you. So, and that's where that law stands. The good news is there's that little hook, which is that there's a recognized derivative right to freedom of information. But what I would say is that, as the experience I've been describing sort of shows, we'll only get that derivative right to be meaningful when people, Canadian citizenry, are sufficiently outraged, for example, by the fact that they can't get access to government information in the Prime Minister's office, and actually, it becomes an important social issue, which frankly, I don't think that case, was not really on most people's radar, and that's why the Supreme Court didn't feel pressured to change it, in my view, and so I think it's consistent with sort of Supreme Court Canada following the lead of the Canadian citizens, and in that scenario in which the Canadian citizens have not yet shown sufficient interest to motivate judicial change.
Yes. Thank you, Ryder. I think this is a particularly nice message to hear at the Federation of Social Science and Humanities, where we want to always to say that indeed the reason why CCLA has been doing this is we need you. We need the social scientists and the humanities to really help us, because the message of civil liberties is not a legal message. It's a societal message, and we can litigate. We do litigate, and we'll continue to litigate. But at the end of the day, we need really an embracement of the demand by the general public. And in this context, we need media experts, we need historians, we need political scientists, we need literature, we need film studies to help us along the way. But we also need lawyers, and I'm very pleased that Doug has, maybe you need a geographer to come to
I had an orientation problem.
So Doug Elliott is the founding partner of Roy Elliott O'Connor LLP, and he has a litigation practice that is increasingly focused on class actions. He's rated by S.C.R as one of the best class action lawyers in Canada, and he certainly has been recognized by Lexpert and the Who's Who in Canada by U of T. He was given the Law Society Medal as well in 2010, and I think he is well known, I think, in his long litigation experience with the Charter in the context of LGBT rights and at EGAL. And I'm so pleased that il est ici aujourd'hui. Merci beaucoup, Doug, d'être ici.
Okay. Hopefully I'll do better. Well, good afternoon. Thank you very much. It's a pleasure to be here. So, oh, I need to
just click it on
the left hand.
Is that better? Can you hear me now? Okay. So, given my topic this afternoon, I thought we should start off with a couple of old queens. Well, all right, 3 counting me. My thesis this afternoon will be that the impact of the first 30 years of the Charter of Rights and Freedoms has been transformative for Canada's LGBT community. So perhaps writing a little more optimistic note about the positive role the law can have. This rights revolution was a symbiotic process between law and social change, but there can be no denying, in my view, the powerful impact the law has had on the improvements achieved in social acceptance of LGBT persons in Canada. The Charter gave a new and powerful tool to the LGBT community who, for the first time, were able to resort successfully to the courts. The high-profile nature of the litigation that drove our human rights revolution engaged all sectors of society in a dialogue, not just on the place of LGBT persons in our society, but on broader democratic and human rights questions. Today, I'm often confronted abroad with the view that Canada was always a great place for LGBT persons because Canadians are just so darn nice. So let's take a moment to recall Canada before the Charter. Well, it's important to remember, as the anthropologists and sociologists among you might do, that in Canada before contact with Europeans, there was in fact widespread acceptance of sexual minorities, or what were known as two-spirited persons. It was the arrival of Europeans and their traditional Christian teaching on sexuality that began a long period of repression for LGBT persons in this country. The law was a key weapon in the arsenal of oppression. Although there were efforts to resist oppression dating back to at least the 19th century, the modern gay liberation movement began in the USA. In classic American fashion, there it took the form of a revolution, a popular uprising known as the Stonewall Riots in June of 1969. Pride parades now commemorate that resistance to the state's use of oppressive laws against us worldwide. In Canada, we had already gone down a more classic Canadian path of evolution, sparked by a court ruling. In November of 1967, the Supreme Court of Canada confirmed that Everett Clifford must remain in prison for life or until cured of his homosexuality. Within weeks, Canada's dashing new Minister of Justice, Pierre Elliott Trudeau, famously proclaimed that the state had no business in the bedrooms of the nation. Within 2 years, consensual homosexual acts between adults in Canada were no longer criminal. However, it's important to remember that despite that great step forward, further progress in the 1970s was minimal. We remained very marginalized. We were refused authorization to hold pride parades, and we did not prevail in a single court case. As the 70s wore on, the climate of homophobia became worse, increasingly overt and toxic, culminating in the infamous mass arrests of the bathhouse raids in Toronto in 1981, Canada's largest civil arrests until the G20. So it was a very bad situation indeed in 1981 for the LGBT community. On a rainy April 17th in 1982, Canada finally gained complete control over its constitution. As part of the new Charter of Rights and Freedoms, we Canadians now enjoyed an equality guarantee in Section 15(1), subject only to the reasonable limits on those equality rights permitted by Section 1. However, as part of the hostile environment for gays and lesbians in 1981, it's important for us to remember that our governments refused to add sexual orientation to the new equality guarantee. However, they did leave the door to freedom slightly ajar by keeping open the possibility of so-called analogous grounds in Section 15. We originally had a closed list that did not include sexual orientation, and they changed it to an open-ended list that left the possibility that there might be other unnamed analogous grounds. And the government was given 3 years. There was the equality holiday. The government had 3 years to reform their laws before they would be subject to any legal challenges. So the equality guarantee didn't actually come into effect until April 17, 1985. It's largely forgotten now, but there were some early signs of hope that the Charter might spur legislative reforms. The Charter, as I've indicated, contemplated the government would proactively reform their laws to bring them into conformity with the Equality Clause. In response, Ontario, for example, amended its Human Rights Code to add sexual orientation, using the Charter for political cover for a reform that had been controversial for many years. Ontario was only the second province at that time to add sexual orientation to their Human Rights Code. However, an extensive series of amendments recommended to the federal parliament by the Boyer Committee, which was charged with reviewing Canada's laws to make recommendations about bringing them into conformity with Section 15, all of those recommendations to do with sexual orientation were completely ignored. Not a single one was enacted by the federal parliament. In fact, to the everlasting shame of our political classes, one law remains unchanged to this day, despite a recommendation for reform by the Boyer Committee 30 years ago. And that is, we still officially have a higher age of consent for anal intercourse than for vaginal intercourse to this very day. While some feared that the new charter would give too much power to judges, we in the LGBT community knew that the judges were likely going to be our only hope. Frankly, I agree with Ryder about this, given the conservative nature of our judiciary and the hostile social climate that we were experiencing back then, at the time, at the beginning of the Charter 30 years ago, I personally, frankly, did not hold out much hope that the Charter would help us. I was to be proved dramatically wrong. One of our earliest and greatest successes, surprisingly, came in the context of our military. Quite a strong contrast with what's happened in the United States, thanks to the bravery of my friend Michelle Douglas. It was remarkable how little fuss this court ruling attracted, but in part it was because Prime Minister Mulroney used the court process to leverage the political process. He chose not to appeal. We've seen this pattern repeat itself again and again. The politicians don't want to take action. There is a court ruling, and they simply accept the court ruling. And if you read Mulroney's memoirs, there's a very entertaining passage where he talks about the meeting with his caucus after this court ruling. They were all up in arms about it, and he said that he believed that 10% of the people in the room were gay and lesbian, and he didn't think that anyone in that room should be subjected to any kind of discrimination. That was the end of that discussion. Now, we didn't win all of our cases, contrary to what some people may think. But I will say that we formed the view that simply bringing the cases had a positive effect. For one thing, it was invigorating to be able to stand up to oppression, and it was intimidating to our opponents to realize that we were, that treading on us was a bit like treading on a porcupine. My American friend and colleague Evan Wilson describes this process of bringing cases that you don't necessarily win as losing forward. Egan is a good example. And there's Jim Egan, who is one of the great pioneers of the LGBT movement in our country, someone I greatly admire. Even though we lost the Egan case under Section 1, we established a couple of key legal principles in the case. First, that sexual orientation was an analogous ground, and second, that same-sex couples were entitled to the protection of Section 15. The second principle did not necessarily flow from the first. The high-profile nature of these cases sparked debate about LGBT issues. However, they also caused Canadians to consider such broader democratic questions as the role of judges, and which was very much a concern of the judges in the Egan case, and the appropriate place of religion in our society. The Breen case is a critical one for at least 3 reasons. First, it marked the first time we actually won a case outright at the Supreme Court level. Second, the Supreme Court embraced Professor Peter Hogg's dialogue theory. It's a very important concept in constitutional law, a controversial one, which sought to legitimize the role of unelected judges under the Charter by characterizing the process not so much as a kind of confrontation where the courts overruled governments, but rather a process of synthesis between the 2 branches of government. The third reason it's important is because in a dramatic example of this type of Hogg dialogue, Premier Klein expressly refused to invoke the notwithstanding clause to overturn the ruling, saying that he had been horrified by what had been said about gay and lesbian Albertans in the wake of the ruling. M versus H was our next big win when the tide fully turned. Same-sex couples were entitled to all of the same rights as common law couples. The federal government made sweeping changes to its laws. Only the question of marriage was left untouched, but not for long. We chose to hold a wedding at the Metropolitan Community Church of Toronto on January 14, 2001, and to publicize that wedding widely. It had a dramatic positive effect on public opinion and triggered a huge social debate. We launched a case demanding that the marriages be recognized, and on June 10, 2003, we won. The battle played out across our country and culminated in the successful same-sex marriage reference in the Supreme Court of Canada. And there I am at the front with none other than Peter Hogg between me and Martin McCarthy. We call these the good guys pictures. But, the Martin government then enacted, the same-sex marriage reference was successful. The Martin government then enacted a law that extended same-sex marriage across Canada. Harper tried to reopen the debate when he formed his first government, but in the minority parliament he faced at that time, he was shot down in flames. And he has not dared to revisit the question since, and I think that's because public opinion has shifted against him. The M versus H reforms had left behind our senior citizens. In the Hislop case, one of our other great pioneers won a multi-million-dollar class action recovering CPP survivor pensions, the largest financial recovery by gays and lesbians for discrimination anywhere in the world, and I believe also the largest financial recovery for a charter under the Charter. It's nothing short of astonishing that we've achieved the greatest success of any group under Section 15, especially considering we didn't even make the cut back in 1982. I'm still stunned, frankly, looking back at the last 30 years, that the notwithstanding clause was never used against us, not even by Alberta. One of the reasons the Charter worked for us is because, in contrast with the political arena, in the courtroom, decisions are based on evidence. We have been blessed to have had outstanding scholarship to back us up from social scientists at home and abroad. The largely unsung work of Canadian social scientists who have testified for us for free, people like Professor Barry Adams, has been critical to our success. So allow me to take a moment for those of you in the academic arena who have helped us along the way to take this opportunity to thank you for your generous assistance from the bottom of my heart. We still face challenges today. We like to think of ourselves in Canada as leaders, but frankly, in some areas, we're slipping behind other countries. Chile, for example, has recently dropped restrictions on gay men donating blood, saying that it's discriminatory. Well, in Canada, we still ban any gay man who has had sex even once since 1977. We're at the back of the pack worldwide on that issue. Argentina recently passed a comprehensive law protecting trans folks from discrimination, while in our country, only the Yukon Territory, only the Yukon has had the courage to take this step. There's still work to do here, but progress will come, thanks to the Charter and its positive impact on Canada's human rights culture. While we can have high-minded debates about legal principles and the role of law in our society, the simple fact is that the Charter has made a dramatic positive difference in the lives of everyday Canadians in the LGBT community. I should know. Thank you very much.
So we do have time for questions and debates. So please, I see lots of hands, so Madame, then Monsieur, and then Madame Adela.
I just have a question. It's not related to any particular, so like if you want just to elaborate, if you have anything to comment on that. I think it fits in our panel. I'm curious why the charter didn't have any impact on the decision to discriminate against immigrants with mental or physical disabilities. I think and I know some of the argument, because immigrants are in between because they are outside of Canada, but I just think there would be space to say, but what does this law say about the dignity and equality for persons with disability here in Canada? Because the message you're sending them is, oh, do you know, you're lucky that you're born here. That's why we accept you and we respect your rights. But were you born outside, everything would change. You would be considered a burden.
If I can, I'll just comment. I'm going to comment on the disability issue, and I'll leave the foreign law issue to others, because it's always fascinated me. The physical disability folks did get added to the list in 1982. There were two groups left off originally, sexual orientation and disability. And disability, because it had been the International Year of the Disabled, they managed to guilt trip the governments into getting added. And yet their track record, it's not just on immigration, their track record generally is pretty lousy compared to the gay and lesbian community. And I think someday I'm going to write a paper with David Lepofsky about this, because we've both thought about what the reasons are. But I think that one of the main underlying reasons is that in many of the cases involving LGBT rights, it didn't cost any money. There's a really pernicious, we could have a whole panel on it, in fact we did recently, and others, about the impact of money on the charter. It's been very insidious. You know, one of the reasons we lost the Egan case is because it involved money. And Justice Sapinka was at least honest enough in that case to say, well, this could have an impact on the Treasury, so we shouldn't go too quickly. And even when we argued the Hislop case more recently, in the oral argument, Justice Rothstein was all over us saying, who's going to pay for this? This is going to cost a lot of money. That was the focus of concern of the bench, was where's the money going to come from? And I think that's either on the front of the mind or the back of the mind for our judges. And frankly, I think it's distorted a lot of our jurisprudence. And in many of the cases, like the Otten case, a famous case we lost on disability, I think the role of money is invisible and it twists the jurisprudence because the judges don't have the courage to talk about it honestly. Sorry to be negative after being so positive.
I'll speak to the born abroad issue. So the Charter does in fact protect against discrimination already on the basis of national or ethnic origin, and in Andrews, that case I was talking about, they extended it to citizenship. But there's two problems, and they're kind of related to what I was talking about a richer understanding of dignity, who gets to argue. So one of the things is you actually have to be physically present. You have to be in the territory of Canada to have the ability to launch a claim of that nature. And so that can be a barrier. So can you have someone here launch a claim on immigrants' behalf? Well, in fact, there's been quite a complicated jurisprudence that has said, in essence, no. It's something that we call technically the law of standing. So you have to actually have suffered the injury, the rights violation yourself, unless you can meet a very, very strict test. And what happens in immigration cases in particular is the government has a really strong incentive to settle the case at the individual level, give the ministers discretionary, use this discretion. And then it's too much of a burden on the individual to expect them to, because they would potentially have the standing once they're here, it's too much of a burden to expect them to continue with the litigation, like the trade-off is too severe. So there's other issues as well, but I think there are structural, technical rules that inhibit the Charter's ability to deal with immigration.
Yeah, but can I just add something? I understand your argument, but I'm pretty sure you heard the case of Angela Chester. She was in Canada, she came to Canada, so some immigrants have the chance to come to Canada, and she was the one that refused the ministerial permit because of this issue, because it's not affecting only me, it's actually discriminating against everyone, and that she loses.
I actually do agree with you that the next wave of big charter issues, I mean, we're in the Supreme Court on discrimination on the basis of immigration status, has been under-theorized, under-thought. There was Andrews, which was the first case, there's Lavoie, another case, and now we're struggling, and it's not only cases, we also have, I think, a duty to demand that the government, in their own policy, incorporate charter analysis, And this is a real struggle, to say the responsibility to protect the Constitution is not just the courts, it's the government as well. So I think, we have to, it's a work in progress. My sense is that we have to continue to do the good work, the good research that will support the claim, start at the political level, societal level, get a couple of good media thing, and then get the right case, and that's how you move forward.
And just to add, I think this may be one of the issues where politically, in terms of the court, the orientation of courts, you will have a very difficult time getting a court to take on really scrutinizing the ability of the state to make decisions about who gets in. It's seen as an essential question of the sovereignty of the state as a political unit. And so we saw that in Cotter, for example, the second decision of the Supreme Court in Cotter. It's really tough. I think political action has to be a huge part of the strategy.
Great. Chris Wells, University of Alberta. I'm in the Faculty of Education. I'm interested in that question of the charter and our public education system, in particular right now, and gay-straight alliances and what seems to be the revisiting of the crux of the issue of Mark Hall several years ago. I'm also interested in the role that the CCLA can play. When we look at, for example, the United States, I find it astonishing to see that 1 in 10 high schools in the US has a gay-straight alliance when we consider how conservative that nation tends to be on LGBT issues. And the predominant reason for that is the ACLU is suing the school districts. Yet I haven't seen that same kind of movement here from the CCLA when students have been denied the right to start gay-straight alliances in their schools, particularly as we're seeing in the Catholic schools. So my question tends to be around this notion of the charter in section 15.1, the equality provisions, which Douglas has so eloquently outlined that evolution, versus the denominational rights. When are we going to see, or are we going to see that issue finally resolved? Do we want to see it resolved?
Well, I'm the lawyer for the Ontario GSA Coalition, and I was involved in the Mark Hall case. So I'm happy to speak to this issue. We're just now, the process is in a very dynamic state right now in Ontario. As for those of you who aren't from this province, we have a special situation in Ontario where Catholic schools have certain rights that are guaranteed under Section 93.1 of the 1867 Constitution at a time when Catholics were a marginalized minority in this province. Irish Catholics would be turned away from jobs and from homes, and things have changed a little bit. We have an Irish Catholic who's the premier, for example, but the Section 93.1 is still there. So there's a tension between the equality guarantee and Section 93.1, and the Charter expressly says that it was not meant to disrupt the denominational school rights of 1867. So there's no question, we know from the Adler case, of using the Charter to overturn Section 93.1. You have to accommodate to it in some way. So we're going to have new legislation before the legislature rises on June the 7th that now is going to, I'm pretty confident it will pass because I think it has the support of the Liberal caucus and the NDP caucus that will expressly guarantee the right to have a great gay-straight alliance in Ontario schools. In other provinces, it's less problematic. I mean, they're very progressive in Newfoundland, for example, despite the fact they have a conservative government. We will then, I think it's pretty clear based on the statement made by Cardinal Collins today in the Catholic Trustees Association that they are probably not going to submit to this legislation, and they are probably going to refuse to comply with it, and so we will be, I regret to say, I think we will be in a litigation environment in September. but I can tell you that I'll come to the defense of the Canadian Civil Liberties Association and tell you that they have already been active behind the scenes on this file, and that we have, they're not part of our coalition, but they have been working in partnership with us along with the Justice for Children and Youth that were involved in the original Mark Hall case and the Ontario English Catholic Teachers Association. So I think you will see come September that there's going to be very strong support for kids in Ontario schools from the CCLA, from the coalition, from other organizations. And I don't think that I think they will find it will be the porcupine problem again for them in September. And I feel fairly confident that the question is going to be resolved in favor of the students again, as it was in the Mark Hall case, because I think I think for some time now, the Catholic trustees and especially the Catholic hierarchy have overstated the scope of their authority under Section 93(1). They seem to think they can have Catholic light bulbs and Catholic tiles on the floor. And that's not, if you had told someone that in 1867, that that's what they were signing up for, we would never have had Catholic schools in this province. Certainly not.
Well, actually, I'm just going to say, send me your articles, because we were interested. Our argument was on freedom of association. To say, to try to kind of come at it slightly differently. And I'm happy to see what can be done elsewhere in Alberta, so just reach us to us. I think we're quite interested in this. To me, I think, once you win, there's always the remnant of little issues. It's very interesting internationally to see Argentina just got, they had the same-sex marriage. I sent them, the work that we had done on the marriage reference in Saskatchewan, and all the, so it will happen there as well. So you see the waves of cases of issues that are arising, and we can do faster. You don't have to take all these steps. I mean, if you predict it a little bit, you can get a little faster. So I think we're learning, but I think we should don't hesitate to tell us to be better too. Great.
Well, what we need is to get that information and a letter from the CCLA into the hands of students that can present it right to their school boards. That's what's been happening in the U.S. before. The threat of litigation is what moves these school boards.
Well, actually, you're right. I don't know how many times we teach in the high schools in Ontario only, though. That's the only funding we got. But students call us when they're threatened with suspension for all sorts of. The minute that we write and say, "Oh, we would ask you to reconsider, and we're watching this case with interest," then obviously the students, the same problem arises. The problem gets resolved for that student, and I think we had one student in Alberta that called us, and we got his problem resolved. But we just keep open the lines of communications, because I think we really need to be more active. I have Madame, and then we'll try to get 1, 2, 3, 4. Yes.
So I guess one question for each panelist, real quick. On Section 293 of the Criminal Code, I think I'm not sure I understood completely, but you were talking a little bit about the intention of the law. If the law was intended to, that particular clause was intended to protect women. But seeing as how it goes back to the beginning, like it existed in the first criminal code, what was the original intention, and does that matter for the legal arguments around that clause? The reference to the Access to Information Act as a derivative right, I'm curious if the court at the time said anything about the Privacy Act, or if there's any thinking that you might contribute on that point, because sometimes people see those two things as being in conflict. And I know Gary Kinsman has done some interesting work around how the Privacy Act gets enacted, and whose interest in the thing. And then finally on the influence of money, I think, I'm just wondering if you think that the undue hardship clause in the Canadian Human Rights Act is the source of some of that, or if you have any other thoughts about it.
Question?
Yes, great question, and another one of my big problems with the reference. So what you're talking about is what we call the initial purpose of the law. The argument I was making was, what would be a purpose of a polygamy law that would pass charter scrutiny? And harm prevention is certainly one. If you go back to 1892, almost every scholar who studied the issue has concluded that the original polygamy offense, as it was inserted in the code, was put in place because of a fear of an influx of Mormons from US territories where polygamy had been outlawed. So it reflected actually what we would call an animus or a dislike of that group. And the initial law actually made specific reference to the form of celestial marriage called Mormon polygamy. And that would, in essence, decide the case because we have a very strong rule in charter law that you have to look at the purpose of the law as it was enacted. What Chief Justice Bauman did was, in part, using this Western civilization argument, he said, well, no, polygamy has always been concerned with harm to women. It's always been about protecting women. And the fact that in a particular historical context, you might have some legislators that were motivated by bias or animus is not necessarily irrelevant, but it doesn't actually answer the question. And my point is simply that to say that in 1892, Parliament's intention was with the welfare of women in marriage is a ridiculous argument, given that marital rape was not a crime, and in fact was not a crime until 1983.
Also a good question about access to information and privacy. It allows me to make a point that I wanted to make when I was speaking about. So the short answer to the question is, it's Access to Information and Privacy Act, and so the Act itself is intended to balance both access to government information and privacy. So where the government has private information, if you're doing an access request, then that should be redacted, just as an example. So it is the job of the courts to balance those two things. One of the points I wanted to make about having the courts just reflecting what's going on in society, one of the dangers is that there's, in my view, no reason why you can't have regression. And in fact, I think we've seen it in connection with civil rights. And I think freedom of expression has, it's a quite a mature right in Canada. Most of us aren't too worried about what we can or cannot say. But I do think that privacy is going to be the hook on which we'll see scaling back. I think certainly we just argued a case a couple of weeks ago. The CCLA was an intervener in a case called Bragg. And I was on for a media coalition, which took a position slightly different from that of the CCLA. But Bragg is a case, it's the Facebook bullying case, where it's an access to justice courts, this access to open courts. A young woman was bringing an application to identify this person who had published this false Facebook account of her. And so she's really just actually, for the moment, trying to get the identity of the person. The court said, well, you can do that, but if you want to do that, since it's an open court system, you have to disclose your own identity, and you can't have a publication ban. She wanted to ban over the content of this fake Facebook page and her identity. And I think there's a real danger there. In fact, the CCLA's position was that she should be allowed to be anonymous, and obviously there's others who will take that view. But I see that as a perfect example of an area in which you could see the open court access being scaled back because of this now growing importance of privacy. Now, some people won't see that as a bad thing. Maybe our privacy is in need of greater protection, but in my view, if we're going to be recognizing and accepting rights, we shouldn't then be scaling them back because social mores change.
I just want to address the financial burden issue on the Canadian Human Rights Act. I wish we had the Canadian Human Rights Act test. It would make it more honest and clear about the role of money. I can only think of one case where the court did it in a way that was least transparent, which was the Newfoundland Alliance of Public Employees case, where they, and a lot of people have criticized the result, but at least the analysis was honest. The court said, yes, these women are being discriminated against, but the Newfoundland government can't afford to pay them equal, because otherwise it's going to impact on hospitals and schools and other things. I would much prefer that kind of honest analysis, but instead it gets kind of woven into, they always try and win under section, they never want to get to section 1. They never want to actually lay the financial cards on the table, because half the time it's nonsense. In the Hislop case, their own actuary testified it would have 0 impact on the Canada Pension Plan. So small, it would be like a drop of water in the ocean. And still the judges were preoccupied with that drop of water.
Well, I was going to suggest, indeed, I think there's a, André Lajoie wrote a book called Jugement de Valeur, and she makes that claim that if you don't ask for money, if you ask for symbolic victory, you can win. She makes that claim for women, she makes that claim for LGBT and for Aboriginal people. Once you want to redistribute, you know, you're going to face a different thing, because judges feel uncomfortable with distribution of money, even though indeed they do it all the time. It's just not as clear. And I'm with Doug on this. I think I want the right to challenge evidence of the government. I think it's what, you know, I don't. We may not win, but at least we'll. You know, society will have a right almost to evidence-based decision-making, as opposed to just political wash-wash. What I suggest maybe is we'll ask the 3 questions, and we'll try to respond in a more you know, collective way. Monsieur, Sir, Madame, and...
Thank you. I suspect you have just answered my question already, but it is so inexpert that I will at least put it forward, because I'm not sure I fully understood. I was struck by a Leaf statistic that 44% of Aboriginal women in Canada live in poverty. For Aboriginal women, the statistics are much more. This is clearly a state that goes to dignity, equality, and freedom. Should there have been more progress within the Charter itself for the poor in Canada to claim space for the assertion of economic rights?
Great questions.
I heard the first speaker say that women have been successful in being able to win a case that has been brought against them, but never successful in a case that they have launched. And I'm curious why that is the case.
My question is on the polygamy reference. So what I was wondering about is that since it was a reference case, and you were arguing that it should be changed or it should be modified so that women aren't criminalized, like what is the actual likelihood of that happening since it was a Supreme Court case? And if it is likely, what would the process be? Like would it go through the lower courts or would it be addressed by the Supreme Court directly? I'm wondering if the reference was a unanimous decision or if there were points of dissent that could help that argument. And is it likely that it will be reviewed judicially or politically more?
I suggest maybe you respond directly to that question because it's a little bit more technical, maybe the last 2 questions. And the issue of socioeconomic rights, I think we can ask everyone for their comments since it's pretty exciting.
So the polygamy reference was put to the Supreme Court of British Columbia, which is a superior trial level court. It is actually the first reference of its kind in Canadian history before a court of that level. Normally references go to provincial courts of appeal or the Supreme Court of Canada. The British Columbia government was explicit that it did that so that it could introduce mountains of evidence, have it reviewed by a single judge, and get, hopefully, a decision interpreting that evidence in the way that it wished, which is exactly what has happened. The reference, technically, of course, is not binding as a matter of law. It's simply advisory. But we have a tradition of references on such important issues being appealed to higher courts and ultimately to the Supreme Court of Canada. The Attorney General of BC, which is the only party that technically would have standing to bring the appeal, decided not to. It could always relaunch a new reference to the BC Court of Appeal. It has unlimited discretion to do that. It has decided not to do that, and instead to simply proceed to apply Section 293 in the province of British Columbia to prosecutions. So what will happen is someone, Winston Blackmore, will be charged, and he will unquestionably re-challenge Section 293. And I hope that happens because, in the event that a prosecution actually occurs, because we need higher courts to look at the reasoning of Justice Bauman in the Supreme Court of British Columbia and hopefully to reject it. And just a technical point, all of the findings of fact that were made in the reference, in my view, are not owed a lot of deference or weight by the appellate courts because they were in fact findings of fact in the reference.
Just on yes, the answer is yes. There's a huge gap in the charter with respect to economic equality. It could have potentially been filled in connection with Section 7 of the charter, which protects security of the person, but that's been found not to apply to economic rights, and I think some of the reasons why have been discussed already. And just to tie it back also to freedom of expression, and this is something that the CCLA knows well because they get communications from people who are being sued for defamation and can't. So they have many good defenses available to them, but the cost of advancing those defenses is prohibitive, and that goes to libel, chill, and just a much larger problem of access to justice in this country, which is fortunately increasingly a debate within the legal community, or at least a discussion within the legal community, although not as much as you might expect. I mean, clearly there's a conflict of interest within that discussion. But once again, you know, where's the outrage? Where's the outrage about the status of Aboriginal people, the economic status of Aboriginal people in this country? So, tying that back to my theme, I think these are things that could be helped through the law, but there needs to be more activism